Today was a status hearing in the state of Arkansas versus Andrew McGann. It was exactly what it sounds like, a hearing where all of the parties arrived and said the status of the case. I noted to the court that our discovery was complete. We set future court dates and dealt with some procedural motions that are routine. 4 orders were entered, mainly dealing with the defendant's ability to obtain records from the state. There were 19 motions actually filed earlier this week. 12 of them are what I would describe as procedural in nature. The remainder are all a form of challenging the death penalty that are typically litigated in any case where the death penalty is being sought by the state. The state will respond to those motions 10 days before our next hearing, which will occur on January 15th. I've litigated these types of motions many times over the last 20 years. I'm confident that the law is in the state's favor where the death penalty will remain an option in this case. The state will not be waiving the death penalty in this case. It will be the state's intention to allow that question to be put to a jury when this case is eventually tried. Because of the gag order that's in place, I'm not going to comment on the evidence in this case. I will tell you that probably getting this case to trial, as I've said before, will take a little longer than what everybody expects. A case of this nature, on average, takes a couple of years to get to trial. I obviously would like to do that as fast as possible, but that's the typical course on these cases. The high-profile nature of this case will not change the nature in which the state approaches it. If anything else, the high-profile nature of the case is making it where the state's taking extra care because of the weight of the proceedings reminds us of how serious the crime is.